You don't just want a car, you want a sanctuary. Introducing the all-new Aetheris sedan, with whisper-quiet cabin technology and an interior designed around you. It's not just about getting to your destination, it's about arriving inspired. Aetheris, move beautifully.
A mother admits stealing a tiny Yorkie for her daughter, while another defendant begs the judge for one final...
Do you love Ray?
Sure.
Are you on probation or parole?
No.
Has anybody promised you anything other than what's been stated here today to get you to plea?
No.
Anybody threaten you or coerce you?
No, Your Honor.
You're doing this voluntarily and of your own free will?
Yes, I am.
And because you believe that you are indeed guilty of this offense?
Yes, I do.
Pardon?
Yes.
Yes. On the date of December 22nd, 25, at the location of 1254 E Horse Road in Ypsilanti Township, Washington County, State of Michigan. What did you do at Pet City Pets that makes you think that you're guilty?
I took a dog.
Okay. So you went in, you took a dog.
I stole a dog.
Store was open to the public at the time?
Yes.
You didn't have anybody's permission to take the dog, did you?
No.
And this dog was offered for sale?
Yes.
Was the price of the dog in excess of $200?
Yes. Mm-hmm. Yeah.
What kind of dog was it, young lady?
A Yorkie.
I thought you said a dog.
A Yorkie.
I know, I heard what she said. Oh. It was a Yorkie?
A puppy.
Yeah, but that's like this big.
Yeah.
How big is a Yorkie? What? What do I have about a Yorkie? That's not a real dog. I like big dogs. I had Yorkies, but I lost them because they're so little. They just ran off. I can't find them. That's why I get big dogs. I'm sorry. Sorry. Why'd you do that, young lady? You wanted a dog.
I did, for my daughter.
How old's your daughter?
She's 2. She'll be 3 on May 23rd. So, recently before that,
Pardon?
Someone recently before that stole my daughter's Yorkie.
I know, you guys are going to do something better than this. I'm not going to accept the plea.
Okay.
I'm going to adjourn this out 2 weeks. You guys figure something else out. That's Probable Cause Conference, May 28th, 2026, 9 a.m. And I'm just going to let you know that if what she's telling me is correct, certainly people can do wrong, but I don't know that she should face 1 year incarceration for that. Thank you. We'll see you in a couple of weeks. Bond continue.
Thank you.
You're welcome. Court calls the case, People versus Ashley Tree.
Mr. Douglas for the people.
Troy Gaines, Senior Assistant Public Defender representing Ms. Reed. And would you please state your name for the record, ma'am? Ashley Reed. And just so your honor is aware, she does have her mother here for moral support.
Pardon?
Her mom is here for moral support. This time, we are asking to adjourn the PCC, but to address bond violation. In terms of the bond violation, at this time, my client wishes to vet. She indicates that she did in fact relapse, that and that she has been in custody now since a week ago today. And so we're asking that the court consider taking her and sentencing her to time served for the bond violation. Because, as I don't know if the court is aware or remembers, she knew that she had relapsed. She had gone through her insurance to Henry Ford Hospital in Jackson, who at the time was recommending outpatient treatment. She did explain to them that because of the relapse, that she may, in fact, have to be incarcerated. They indicated that they would still be able to have a place for her upon her release, and that if necessary, they could get her into inpatient treatment. Again, this is through her insurance, so we're asking if the court would consider releasing her with credit for the days served, reinstating her bond, placing her, if deemed appropriate, on scram tether, and allowing her to go into treatment through her insurance, and provide, if the court wanted her to provide documentation of that appointment by Wednesday so that she could get that in, to your honor, she'd be able to do that. I'm sorry.
I have a couple of concerns. Certainly there's the violation of the bond condition, but just the judgment of having a child blow into the sober line. I don't know, and I understand what you're saying regarding some of that, but that's a messed up judgment. That's the only way I can, messed up being a legal term. I don't even know how you get there.
I think you saw her nodding her head in agreement that was messed up judgment. There are, I want to be careful with my words just because I'm not sure who all may have access, but there are other extenuating, triggering circumstances in the household as related to her personal relationship.
Okay.
And she that were part of the relapse and the triggering for that. And she is trying to get out of that situation. She has a license in medical billing. She's worked in that field before, actually over 20 years in that field. And she had just started a new job, a better job that she hopes will position her to be out of the situation that is triggering. And they're holding it for her right now. They were aware that she had this case pending.
All right, respond.
Your Honor, last time that we were here, the people expressed their extreme concerns over the defendant's behavior. I understand she's admitting to having a relapse. I'm not sure if she's going to admit having the child blow into the ruling. I do think it's worth noting, and I would like the court to just have it in its mind that her ruling flow was a .083. So this wasn't as though we had one drink or two drinks. This is very good. And it's a concern to the people that was the point that we got to. I believe last week we discussed that she had been approved for intensive outpatient, and I don't recall Ms. Gaines said on the record a few moments ago, and I apologize if it was going to be inpatient or outpatient, but this does, in my non-medical opinion, screen for inpatient. The history of what I've seen. The concern of the people is I don't know much about the Henry Ford thing, and I would like to learn more before I make the agreements. So at this point, I'm not agreeing to the request for release to treatment, but I will leave it in the court's discretion, and I hope that the court will address any further questions it has of me or anything else. Those.
I know that my client wishes to speak so that you can hear from her. I did just want to clarify my words, that I'm focusing on the relapse because there would not have been any engagement of the child absent that is the whole, that the alcohol issue is the whole issue. And by relapse, I was not at all saying that she had had one beer. That is not what she had had half a glass of wine. I was not trying to imply that by using that word.
And then people don't think that Ms. Gaines was trying to minimize.
Yeah. So she's and she is not minimizing that. She is a single parent. And she has not been in any trouble for 12 years. So she is really hoping to turn this around so she can get back on the track she was before being in this relationship that has triggered all of these, the relapse.
What do you want to tell me, ma'am?
I just want to apologize to you and your court. I'm sorry that I disrespected and embarrassed you. I probably don't deserve a second chance. But I need to prove not only to you and the court, my family, my kids, but myself. I was clean for 9.5 years. This domestic violence case in this relationship, I was diagnosed with borderline personality disorder. I don't know if you know, but it's been a struggle. And I've really focused on that. And I knew as soon as I got triggered by him again, I ran to get help. And I just hope you give me a second chance to prove to you that this is not me. Outside of here, Judge, I coach my kid's middle school softball team. She's in travel ball. She's in travel volleyball. I volunteer at her school. I'm supposed to go on a Mackinac Island trip on the bus with her 8th grade class. Like, I'm not a bad person. It's some of my step choices lately. Drugs are not the answer. And I know that. I was clean for 9.5 years. Sorry, I didn't speak. I'm sorry.
I'll adjourn probable cause to June 4th, 2026, 9 a.m. Defendant having admitted to the violation, I'm going to sentence the defendant to 10 days. Credit 8. Defendant is to serve that balance of those 2 days. Prior to her release, defendant must be placed on a scram tether prior to. Then her bond previously will be.
Thank you.